All right, we'll go ahead and start on time at 6 o'clock. Welcome and thank you for giving us your time today and making time for the partnership workshop with the Arctic Innovation Competition and the U.S. Patent and Trademark Office Western Regional Division. We are so thrilled to partner and to provide you this information. We've got a host of a mix of participants today. Some of you are current AIC competitors, some of you are past AIC competitors, some of you are just darn interested. And so we're glad that you took time to be here today. Some of you are on our advisory committee. I see Brian joining us there today. So thank you all for participating. And as you just heard, it is being recorded so that if you want to go back and grab this information, or if you have to early out, this is about an hour long, no problem. We're going to go ahead and post it, or if you want to share it with a friend or someone that you know. We're going to do about 45 minutes of presentation, and just go ahead and keep your microphone on mute, and there's a slide deck to watch. And after that, we are going to open it up to questions. And no worries if we don't have time to get your particular question answered today. We're going to give you a way to follow up and with your question, or just if you want more information, or if you're really serious and want to take your idea and your patent a little further. I think we're there. Yep. I just wouldn't, please shout out. Arctic Innovation Competition is different this year because we're 100% virtual. And so we're doing a series of semifinals all next week, all starting at 5:30. Just go to arcticinno.com and you can check out the different presentations, starting with the cub, the youngest, and then moving to the juniors, the teens, and then moving into the main division, with the finals being and the award ceremony being next Saturday. So just all the information will be on arcticinno.com. And you can also vote for your fan favorite in each division. And that's a first for us, being able to offer that publicly. My name is Tammy Tragus McCook. I am one of the staff members at Arctic Innovation Competition. I work for the UAF School of Management. Also joining us today is Julie Mason. Julie is the Regional Outreach Officer for the Patent and Trademark Office. And then I'm going to turn it over to Ashley Plies. There's Julie giving us a wave, a quick wave there. Ashley Plies is a student marketing assistant with the UAF School of Management and is the lead on this project. And she's going to go ahead and introduce our guest presenter today.
Hi there, I'm Ashley. I'm part of the Arctic Innovation staff, and I'm here to introduce Steve Kozial to all of us. He's the Managing Assistant Regional Director of the Western Regional United States Patent and Trademark Office. He joined the USPTO in 2007 as a patent examiner and has managed different teams of examiners in computer graphics and digital imaging fields. He's also focused on development of patent-specific programs within the USPTO, including post-grant outcome programs, AIA First Inventor to File implementation, and AIPLA Partnering in Patents, and other patent operations cost and fee modeling. And the Arctic Innovation Competition team is so thrilled to have him here, and we're ready whenever you are.
Okay, wonderful. Thank you, Ashley, and thank you, Tammy, for the introduction and for allowing me to be here. And thank you all for joining and spending a part of your evening. I'm going to go ahead and share my screen now, and hopefully you all can see that. So as Tammy and Ashley mentioned, I've got a number of slides here, kind of giving you an introduction to the patent system, talk a little bit about what patents are, what they cover, what they don't cover, maybe just as importantly, and what resources are available to you as well if you're looking to kind of take the next steps and either pursue patent protection on your own or figure out how to work with an attorney to really protect the ideas that you have. So fair warning, I do have a fairly large amount of content that I'm going to be moving through quickly, but these slides will be available to you after the hour or so that we have together this evening, if you'd like to review them on your own. And I am available after this presentation. If you do have questions, or if you want to, more detailed conversation about something that you're working on individually, happy to have a one-on-one chat with you after this presentation, or sometime in the future as you see fit. So with that, we're going to go ahead and jump right in here today. So what we'll try to cover, like I said, in the next maybe 40 minutes or so before we open it up to Q&A, just a brief overview of the patent system, how we kind of came to be where we are. We'll get more specific about the patent itself, kind of take a look at the anatomy of the patent and what happens from the time that you actually prepare and file your application to the point that that application gets issued as a valid enforceable patent. And we'll conclude with some of the resources that are available. And so to kind of start at the beginning, patents are one area of the law that draws their authority directly from the Constitution. You can go all the way back to Article 1, Section 8, Clause 8, that really provides the legal basis in the United States for the patent system. So that that means that all the way back to the time of Thomas Jefferson, the United States was receiving patent applications, reviewing them, and issuing them. And in fact, Jefferson, at least if you believe the legend that floats around the office, was the nation's first patent examiner. And in fact, would keep incoming patent applications in a shoebox under his bed, and would review them on the weekends. So the history of the patent system in the United States is as old as the country's founding document. So what is a patent? Many people think that a patent automatically gives them a monopoly on their invention, and I would offer a note of caution around that interpretation. I think it's more accurate to say that a patent gives you the right to exclude others from making, using, selling, offering for sale, or importing that which you claim in your patent application. So in other words, you have the ability to, if you see someone infringing on your issued patent, to seek injunctive relief by going to a district court and filing for an injunction against further sale or importation or manufacturing of that product. But there's no federal agency that's going to police your patent for you. And so that's what the right to exclude others means, is that you as the right holder have to monitor, your competitive landscape and see which of your competitors may be infringing or trying to copy that which you have patented. So rather than granting you the sole monopoly, it really just grants you the ability to exclude others from the market. And the patent term is limited. It's 20 years from the date that you file your application. And it's territorial, meaning that a United States patent provides you that protection, that right to exclude, only within the United States. There's really no such thing as a worldwide patent or a global piece of intellectual property. All intellectual property is territorial. So if you're looking to sell your product overseas or manufacture your product overseas, your United States patent is not going to be enforceable in those jurisdictions. So especially if you're going to be deriving a significant amount of revenue from a patented product outside of the US, you should really look into the corresponding jurisdiction's patent system and think about what kind of patent protection you can get in that jurisdiction. Because like at the end of the day, there really is no such thing as a worldwide patent. And so when we talk about patents, and when you may watch, Shark Tank, and they always ask, well, do you have a patent or is it patent pending? 99% of the time, what they're talking about is what we would call a utility patent. And I show this slide briefly just to give you a sense that there are technically 3 different flavors or types of a patent. The overwhelming majority are what we call utility patents. These are the traditional patents for invention. So when you think of a patent, you're more likely than not thinking of a utility patent. But patents also have the ability to cover the ornamental design of a functional product. And so that's the middle category here of design patents. And the way to think about a design patent is if the ornamental look and feel of a product is important to you, if that helps distinguish your product from your competitors, then the design of that product is important and can be protected by what's called a design patent. So the utility patent protects what the invention does, the function of it. The design patent protects the look and feel of it. And both can be important. And last but not least, there is an ability to protect plants as well through patents. A lot of times people come up with new seeds that are maybe drought or pestilence resistant, and there is an ability to protect those as well through a patent. So stepping back a little bit, why am I talking to you? Well, I work for the United States Patent and Trademark Office. We're the federal agency that is assigned with reviewing all incoming patent applications, making sure that they meet the statutory requirements for patentability. And once we verify that, we issue the application as a valid and enforceable patent. And we're the only agency in the country that's vested with that responsibility. And that's a photograph there of our headquarters over in Alexandria, Virginia. And I work for one of the 4 regional offices that the agency has, and so we're your Western United States representative from that agency. And so why are we talking about patents, or what's really the end game when we talk about patents, right? The goal is not, if you have an invention, just to get a patent, right? The patent is not the end, or should not be the end game in mind, right? A patent is simply a tool. It's one tool that you have as part of your overall business strategy. A patent by itself may or may not be useful, depending on the market that you're in, depending on your particular business strategy, depending on the age of your company and where you are. So you need to kind of divorce yourself of the idea that a patent is, or having a patent is always necessarily a good thing and that riches will follow. No, a patent is an asset. It's a strategic asset, and it makes sense, sometimes more than at other times. But some of the things that having a patent can really help you with in your company is, and I'm going to jump to the next slide here. It can really be a tool to allow you to license the technology that you have, particularly if you've got a product that you're looking to manufacture and you're not confident that you'll be able to manufacture it in-house. Having the patent can be the key to striking up licensing agreements that enable the vast manufacture of your product without having somebody able to steal or copy your product or your design. And it can also add value to your company as well. I mean, at the end of the day, right? If the patent gives you, remember, that exclusive right to prevent others from copying your product, then that patent creates a barrier to entry in around your invention and for your company. So having that barrier to entry can really boost the value of your company and make it more attractive, either as a potential acquisition target or just overall raising the value of the company. And when you take that value add that patents provide and look at them across the entire United States economy, we estimate that it translates to roughly 45 million jobs that are directly supported by intellectual property, accounting for over 38% of US GDP. And those industries that are what we consider patent intensive industries or intellectual property intensive industries correlate positively to higher weekly pay for the workers in those industries. So there are real tangible economic benefits to successfully pursuing patent protection when it makes sense for your company. So that's a lot of the why of why it might make sense to pursue a patent or why there's economic benefits. Let's dive a little deeper into the what of what actually is a patent. And what we're looking at here is just the front cover of an example patent. And if you've ever seen one, or if you've got one of your own, or you've done patent searches in the past, this should look fairly familiar. And every patent document has what we see here on screen. And I'm not going to highlight every single one of these portions of the document, but you'll see some things that stand out, right? Every patent is going to have what we call an abstract. It's typically a short one-paragraph summary explaining in layman's terms what the crux of the invention is. It's not shown on this page, but every patent is going to have what we call a written description. At the end of the day, a patent document is essentially a how-to manual. How to make and use that which you invented, right? And so you're telling the world, what your idea is, and you're enabling a person of ordinary skill in that field of endeavor to make and use your invention, right? You're essentially giving away exactly how you came up with your invention. And that's the quid pro quo that's at the heart of the patent system. You tell us what you did, you tell us how you came up with your invention. In exchange for that, you are granted the exclusive rights to, like we saw before, make and use and decide who gets to use your invention. So you're providing your knowledge into the public domain, and in exchange for that, you get that 20-year period of exclusivity. And so that's what we call, in formal terms, this written description of your invention. Most patents that you'll look at also have drawings, quite a few drawings. Oftentimes, words only go so far to really describe the invention itself. So drawings can be very helpful in visualizing the different aspects of the invention, or flow charts that show how the different pieces of the invention may connect. And then finally, we've got something called the patent claims. And this may be the most important part of the patent document, the patent claims. If you've ever looked at a patent, you can flip to the very last page or last couple pages of the document, and they'll end with the set of numbered claims. And why the claims are so important is because the claims are what define the legal boundary of your invention. So regardless of what you put in the written description, regardless of what you show in the drawings, if you don't claim it, you don't have protection for it, right? So if you analogize intellectual property and patents to real property and land, you know, you hire a surveyor to define the boundaries of your land, and maybe you put up a fence along those boundaries. The fence in intellectual property is the language of the claims, right? The claims are your fence that define exactly what it is that you've protected in this patent. And this is just a simple example of how one might claim a chair that looks like this. And so we're introducing a chair, and we're claiming its constituent parts, right? A seat, a back that's connected to the seat, support arms, and a base, right? Very, very simple example there. But we'll talk a little bit more about that later on. So that's kind of the basic anatomy of a patent. You may have noticed that every patent also lists what we call the inventor. And there's a lot of confusion sometimes around, well, who is the inventor, or how much do you have to contribute to be an inventor? And it's basically the bar for being listed as an inventor is the idea of anyone who contributes to the conception of an invention. So if you're working with a partner, or if you've got an idea and you're workshopping that idea with a group of people, and you're then taking their input and applying it to the invention, you know, they may be inventors, and they may need to be listed as inventors if you file a patent application. So anyone who contributes to the conception of the invention is legally considered an inventor and should be listed on the application. Okay, so we'll walk through a little bit here from idea to all the way through to filing your application, just to get a sense of what that process flow looks like and what some of the time frames are involved. So you've got an idea. You think it may be eligible for a patent. So what is really patent eligible here in the United States? And this is set out by law in 35 United States Code Section 101. Basically any, and there's the 4 categories here, any process. So that's maybe a method, a series of steps that you can take either to assemble a product or assemble a machine. So anything that could be captured maybe in a flow chart as a concrete series of steps that leads to a tangible result. Any machine, and that's a very broad term, but basically anything and anything that you can construct, any manufacture, anything that's assembled, and any composition of matter. So that compositions of matter often include pharmaceutical patents. So the drug, you may have heard, drug patents. They're protected for 20 years before they go generic, and then you can get the generic version. But basically, those are the 4 categories of what's eligible for protection, along with any new and useful improvements to one of those 4 categories. And those are intentionally broad. The idea is to keep the door as wide open as possible so that as much can be eligible for patent protection as possible. So once you have your invention and you've decided that, okay, it fits, broadly speaking, in one of those 4 categories, the next question to ask is, has it been done before? That's what we call this idea of novelty. And that novelty just comes from the statute. That's 35 USC 102 now that we're looking at. And basically, if we only grant patents on those ideas and those inventions that we can demonstrate have not been done before and would not have been obvious to do. And that is, if that sounds subjective, it is. But it's what essentially this slide is what the patent examiner's job is to review your application, your invention, and to see, again, 1, if it's been done before, and 2, if it would have been obvious to do. And while that is a subjective determination, it's a determination that's based on factual evidence. So the examiner, if they're going to reject your application, has to provide factual evidence demonstrating that, hey, here's a product that either is exactly what you've claimed, or here is a product that is just an obvious, your invention is just an obvious modification of this existing product. And the examiner provides that factual basis or that rejection using what we call prior art. And prior art is essentially any other previously issued patent or printed publication or any other public disclosure that was available to the public prior to your filing date. So anything that was out there in the public domain before you filed for your patent application can be used to demonstrate a lack of novelty or non-obviousness. So practically speaking, what does that mean for you? Before you go through the time and expense of filing your patent application, do a thorough search. Do a search of all of the literature that's relevant to your field of endeavor, whether it's product manuals or maybe there's a trade magazine that's specific to your area, and take a look at the patent literature as well, both here in the US and abroad, because you'd hate to waste the money on an application if within a 15-minute search you found that someone else had the same idea and already published it or patented or turned it into a product and is selling it. So you can save yourself a lot of time and money by doing that search and being confident that you know the state of the market well enough that your idea just has not been done before. So here things get a little tricky when we talk about presenting your idea, because you're inevitably going to need to talk to people either through a competition like this, or you're maybe working with an advisor. You may be looking to get funding at some point, and eventually you're going to need to disclose your invention to others in order to move forward with your business. That's not necessarily a bad thing. You just need to be deliberate about who you disclose and how much you disclose. The basic rule of thumb is that you're always safer having first filed your patent application before any kind of disclosure to the public, to an advisor, or especially to an investor. Because any public disclosure of your invention may inadvertently harm your ability to obtain patent protection for that invention in the future. And the way to think about it is, if you disclose your invention in a public forum, basically you make your, maybe you're looking to raise funding, and so you start a crowdfunding campaign, and you put your invention online and associate it with some Kickstarter or other crowdfunding campaign. That's a public disclosure of your invention. And you have, in the United States, essentially 1 year from that public disclosure in which you can file for a patent application. If you go beyond that 1 year, you are unable in the United States to obtain patent protection on that original invention which you made public. So that's not to discourage you from disclosing your invention and talking about it with others. It's just to note that you should do so deliberately, and that you're always safer having first filed the patent application before entering into those conversations or other public disclosures that may inadvertently harm your ability to obtain patent protection in the future. Okay, so moving on then, we've decided that we have an idea that's eligible for patenting. We kind of did our prior art search to make sure that it's not, to make sure that it is novel and not obvious. We've been mindful about who we've spoken to and how much of our invention we've disclosed to the public or made publicly available online. And so now it may be time to put the application together and actually think about filing the application. So as I mentioned before, right, the patent application really is an instruction manual that describes to a person of ordinary skill in your field how to make and use your invention. And so this, there's a couple slides here that get into detail about that written description portion that I alluded to earlier. And I'm not going to dwell on this right now, but suffice it to say that the written description of your invention has to be written clearly, concisely, and in a way that truly enables one who's reading it to make and use your invention. So in other words, don't leave them guessing. Don't try to deliberately omit key elements of your invention, because that may lead to a rejection down the road. Again, that's the whole idea of the quid pro quo, right? In exchange for that exclusive right, you really do need to tell us how you came up with your invention in sufficient detail and with sufficient clarity that, again, anyone of skill in your art can pick up your patent application and say, okay, I could do that, or I know how to make that, and they're not left guessing or scratching their head and trying to figure that out. So that's legally, that's the idea of enablement. You have to enable others to make and use your invention, and it has to be with sufficient clarity that they're not basically they're not left guessing. So when it comes time to actually file your patent application, so you've written up that user's manual, you've worked with the draftsperson to come up with some drawings, you've got your patent claims, you've got the documents. Now what do you do with them? So when it's time to file, we do note that there is a filing fee. Anytime you need to file a patent application with the USPTO, there is a corresponding filing fee. However, there are discounts depending on the size of your company. Basically, the smaller you are, the less fee you have to pay. And the majority of people who tend to compete in competitions like this, or are associated with this type of competition, you likely qualify for what we call micro entity status. That's a fancy way of saying you get a 75% discount on all fees that the agency charges you. So the takeaway here is substantial discounts are available the smaller you are. So before you pay anything in filing fees, make sure that and double check to see if you qualify for fee discounts, because there are often quite a few that you can qualify for. So assuming you do qualify for the microentity fee, you're looking at around $455 to actually file your patent application, and be able to have your patent application number and say that you are indeed patent pending. Okay, this is a fairly busy slide here, but what it's trying to say is that once you cough up the $455 and file your application, you're not done. Because as I mentioned before, it goes to a patent examiner who's going to review your application for that clarity that I mentioned before. Make sure that you've described your application in sufficient detail and clarity. Is going to do that review for novelty and obviousness. And oftentimes the examiner is going to reject your application. And that's not a bad thing. I'm going to jump ahead here to a chart to show that over 84% of originally filed patent applications receive some form of rejection. And that's not the end of the world, right? A rejection from your patent examiner is really the start of a conversation, the start of a back and forth between you and your patent examiner to see what the examiner wants corrected. And oftentimes it's going to be, something wasn't described with sufficient clarity, and the examiner wants you to add more detail around a certain claim, or the examiner was able to find pieces of prior art that teach part of your invention. And that's not the end of the world. You have the opportunity to amend your patent application, right? And again, as you see here, over 84% of the time, some type of amendment is going to be required. Ultimately, that's a good thing, because you want a patent that you can enforce, right? You want a patent that's going to hold up if somebody, challenges you in court. You want a patent that's going to be valuable when you try to license it. And so the back and forth between you and your examiner through that rejection process is how you clean up the patent application to ensure that it's going to be valid, enforceable, and hopefully valuable to you when you do try to license it or to sell it. And in fact, from that 84% of initial rejections, over 58% of applications eventually reach what we call allowance, where the examiner has no more objections, no more rejections, and gives you the stamp of approval, and you go from having a patent application that's pending to having an actual patent that's been issued, is allowed and is enforceable. And I mentioned this back and forth with the examiner. It's predominantly in writing. However, it can be extremely valuable to just pick up the phone and talk to your patent examiner, especially after you receive one of those rejection letters. You know, you can go back and forth with your examiner in writing for months at a time, but oftentimes a half-hour conversation over the phone can save you literally hundreds, if not thousands of dollars in back and forth and many months of frustration. So keep that in mind. Every action that you receive from the office, every written correspondence that you receive from the patent office is going to have a person's name at the end of it and a phone number that you can reach them at. Take advantage of that. If you're not sure how to respond, pick up the phone and call the person that sent you the letter, and they're more likely than not, they're going to be willing and able to work with you to figure out what's the best way to move your application forward. So what are we talking about in terms of timing? On average, from the day that you file your patent application to the day that it issues as a patent, you're looking at a little bit over 2 years in total. A lot of that is the time spent back and forth with your examiner. Some of it is time and just the backlog in a particular technology area. But on average, it's realistic to say that within 2 years, you're maybe a little north of 2 years, from the date that you file, you can expect the application to issue. And that brings you to the end. That's the end of the journey. Once you get that, what we call notice of allowance, that means, you know, the examiner has approved your application in its entirety. There's nothing left for you to do, and your application other than pay the allowance fee, and your application will issue as a patent shortly thereafter. Okay, so just in the last few minutes, I'm going to talk about some of the resources that are available. One of the resources that we like to highlight is just the fact that we do have regional offices across the country. So we're the Western Regional Office. We cover the 7 states that are on the West Coast. So everything that touches the Pacific, plus Nevada and Arizona. But there are a number of other resources too that we like to highlight. And again, if you joined late, these slides are going to be available to you after the call, so you don't have to try to take screen captures or anything like that of these phone numbers. These will all be available to you. So we do run a number of 1-800 numbers. One of the more popular is what we call the Inventor Assistance Center. You can pick up the phone and talk to a real life person on the other end at kind of any stage in the process. If you're not sure how to fill out a particular form, if you're not sure whether or not you know what you're doing is right as you're preparing your application, you know, the Inventor Assistance Center can really help you with some of those tough questions. And these are all former supervisory patent examiners. So these aren't people you know, that we've just picked off the street. These are people that have made a career working with patent applications and are very familiar with the process from start to finish. So if you manage to stump one of these folks, then maybe we'll figure out an award that we can give you or something, because it's a very seasoned group that runs that's on the other end of that phone number. We also encourage you to consider the patent pro bono program. What this does, it's a nationwide program, and there's representatives in every state, where if you apply for this program, we can connect you with a registered patent attorney who can help you prepare your application and file your application on your behalf. Now, there are some criteria that you have to meet in terms of income levels, but basically, if your income is below 300% of the federal poverty guidelines, and you have not filed more than just a handful of patent applications in the past, you may be eligible to work with a patent attorney at no charge to you. And that can be extremely valuable, because patent attorneys, can charge anywhere from $15,000 to upwards of $20,000 to $25,000 for a single patent application. So that being able to work with an attorney at low cost or no cost through this pro bono program can be extremely valuable if you qualify. And this is just a grid of the particular organizations that administer the program across the United States. We also have law school clinics. These are very similar to the pro bono program, whereby if you apply to a law school clinic, we'll connect you with instead of a registered patent attorney, we'll connect you with a law school student who's under the supervision of a registered patent attorney at that school, who will work with you again to prepare your application and file the application on your behalf, again at no cost to you. And I do want to mention the Patent and Trademark Resource Centers as well. This is a nationwide network of libraries, public, state, academic, that have partnered with the Patent and Trademark Office to provide intellectual property training and the ability to do a patent search. We talked about at the beginning the importance of patent searching. So that's another resource that you have, the Patent, Trademark, and Resource Centers. And I believe one of the PTRC librarians is on this call as well. And so we can connect you with her after the fact. So I'm gonna leave it there. These are just some of the direct links to a number of these programs that I had mentioned, and to some how-to guides on the patent system that may be beneficial for you to review. So we've got about 10 or so minutes for Q&A. So if you do have questions, feel free to unmute yourself and ask. Otherwise, you can type the question into the chat box, and I can try to respond to it that way. So Tammy, if you don't have any objections, we'll
Sure.
open it up for the Q&A.
That is incredible, Steve. That was so much information. It was so well presented. And thank you for generously offering to provide your slides. So you all will get access to the slides and the recording. If you're not familiar with Zoom, there is a digital hand. You can either find it clicking on the participants, or the three dots that says more, or the reactions, or you can just turn on your camera and raise your hand. So who would like to ask the first question? Katrina, you're up first. She's found her digital hand. Go ahead and unmute.
Hi there. Thank you so much for your time. I guess one question I have is if I do not create a patent design, could someone else go and make a patent for it and claim it as theirs and then try and edge me out of it?
Sure. And you broke up there kind of midway through, but I think the question was, if you don't patent it, is there any way to still protect yourself if somebody else tries to come in and patent your design? Is that kind of the basics of the question?
Yeah, basically, like, or can they patent it and try and edge me out?
Gotcha. So in that case, remember the idea of prior art that we talked about at the very beginning. So if you're not going to pursue patent protection on something that's important to you, whether it's a design or a product, but you make that design publicly available, you're essentially entering that into the realm of prior art. And once your design or your invention is in that realm of prior art, then that effectively precludes others from being able to patent that design or that invention. So in some industries, that is called a defensive publication. Because they never really intend to patent or commercialize the product, but they don't want their competitors patenting or commercializing that product either. So instead of filing a patent, they'll publish it. They'll make it publicly available through some type of defensive publication. And again, when I say publicly available, that can be as simple as putting it up on a website, writing a blog post that describes the invention in sufficient detail, right? Anything that can be accessed by a member of the public, enters it into that realm of prior art. And so once it's there, it precludes others from being able to patent it and thereby kind of edge you out of the market.
Thank you so much.
Okay, scanning for other hands.
Alex Kopanen asked about a book. He says, do you suggest books such as Patent It Yourself?
So, one of the restraints that comes with working for the federal government is that we're not in a position to formally recommend commercial products like that. We do just generally advertise, just take a general buyer beware approach. Most of the books that are out there are, have pretty good nuggets of advice. It's those infomercials that you may come across, particularly if you're like me and you have trouble sleeping and you see those late night infomercials about the, there's that little caveman with the wheel. You may have seen that one. Those kind of fall under the bucket of what we call invention submission corporations. And, they are, extremely buyer beware. Let's just leave it at that. They may be able to get you a patent, but it's often so limited in scope that it's really not valuable, and it doesn't protect what you may think that it protects. So if often these services charge, just a few hundred or a few $1,000s, where a corresponding licensed and registered patent attorney would charge maybe $10,000 or $15,000, and you're very much getting what you pay for in those situations. So it's one thing to educate yourself with the books and the literature that you're able to find in order to prepare your own patent application. It's another thing entirely when you kind of turn everything over to one of these invention submission corporations, especially one that may pop up on a browser ad or that you may see as a late night infomercial. So there's often worth less than what you pay for in those situations.
Oh, Alex has another question. Alex, please ask your question.
Yeah, regarding scope, if I have an invention that's basically fairly simple, but I can come up with numerous varieties, or I can broaden its scope considerably. Is it better to be very narrow and say, okay, this is the simple core of it, or do I want to include everything so that theoretically in the future I could get the most money from it? But then I'd presume that I'd have more potential conflicts with other patents.
Yeah, that's a real interesting question, and it gets to the heart of how you think about your claims, and this goes back to the fence analogy that I had earlier, right? The patent claims are the equivalent of the fence around your property, and you know, in the more detail that you add, you know, the more features that you add to the claims, you know, maybe the more valuable it can become, you know, because you're capturing, you know, more useful aspects that you may want to license, that may make it more desirable. But like you said, it may attract more attention at the same time, and it may open you up to a broader pool of potential prior art that can be used in a rejection. So it very much is kind of the tension that's at the heart of claim drafting. You can go very narrow and just try to focus on a very narrow sliver and very narrow patch of land in your backyard. And, you know, sure, that may be easy to get a patent on, but it may not be that valuable, right? You know, if just one little corner of your backyard, or you may step back and try to go very broad and see what's out there. And so that's, you know, oftentimes what we see people do is start very broad and let the patent examiner find what's been done before, and let the patent examiner guide you into how to narrow that, so that you're not infringing on others, so that you're not attracting that undue attention from competitors. And that's the kind of question too, where a patent attorney can be extremely valuable to help you navigate exactly how broad to go in your initial patent application. And the last thing I'll say on that is, you can include as much detail as you like in that written description portion of your application, and you can always add that detail into your claims later in the process. So if you're wondering where to start, we often see that people start fairly sparse in the claims, but very robust in the written description, knowing that they can always transfer the content of their written description into the claims, depending on what the examiner has found, and depending on where the market evolves over those 2 years that your application may be pending.
We are almost out of time. There is one more question from Alex Z. And it dovetails with what you were just talking about hiring an attorney or doing it yourself. And then we'll end and do some closing comments and give you some resources to keep this conversation going offline.
Sure. And generally speaking, we do recommend working with a patent attorney if you can afford to hire one yourself, or if not, going through one of the pro bono programs or law school clinic programs, so that you are connected with a patent attorney. You know, there's so much more. I mean, this class could have easily been, 4 or 5 hours talking about all the formatting requirements of the patent application. Believe it or not, there are spacing requirements and size requirements and font requirements of the document, all the way down the line. So a patent attorney can help you avoid a lot of those issues that may trip you up initially around the formatting, and again, work with you on the strategy of your claims, so that you set your fence where it should be and where it's most valuable to you. So whenever possible, we do recommend working with a patent attorney. But again, if not, there are options to educate yourself, either through the how you do it yourself books, or just read issued patents in your field of endeavor. Do a search, get a sense of who the major players are, and look at how they write their applications. Look at how they've drafted their claims. Look at what drawings they include, and maybe that can be a template for you to get started on your application.
All right, well, we are out of time and we've given so much information. You had great questions. Thank you so much to Steve and to Julie from joining us from the U.S. Patent and Trademark Office. We will definitely send out this recording as well as the slide deck and plus contact information, so you can email either Steve or Julie and get more one-on-one questions answered or more information specific about your idea or your invention. Good luck to those of you who are competing next week. You are presenting this publicly, so take this information and do what you need to do with it. It will also be published on the website for those of you who have opted in to the fan favorite voting. But you're starting to market your idea, so it's pretty exciting. So thank you all for joining us, and look for that follow-up email with some information. And Petra, you joined us a little late, but you'll get all the slides and the recording. So thank you and good luck to all the competitors and all of you who took the time to invest in your ideas and getting this information. Thank you for the thumbs up. All right, thumbs up from everybody. I like it.
Yep. Have a good one.
All right. Take care, everyone. Good night.
Thank you.